That's also the EU-UK negotiations, the implications for Scotland and for Scotland's government, if indeed we got independence within the EU. So that should be interesting. But tonight, well, I'm John Purvis. I'm chairman of Fight for Europe, which we set up a couple of years ago to fight our corner. And I'm also a member of the executive committee of the European movement in Scotland. This is, in this first part of the session, we'll hear mainly from Mark Lazarowicz, who, as well as being chair of EMiS and a full-time advocate, also chairs the Citizens' Rights Project. And Mark will be explaining what rights EU citizens and their families had in the UK before Brexit and what rights they will have in the future, as well as how they can ensure those rights are respected. The UK government settlement scheme obviously has an important place in that, and we also have Mari Cruz Garcia, who's joining us, and Larissa Slaney, who is working mainly with the German-speaking community, both members of our Fight for Europe group. And they will be giving some real-life examples of just how difficult the allegedly simple process of achieving settled status, and if you want to go further, British citizenship can be. And following these presentations, we'll have plenty of time for questions, so please pitch in on that. After all that is done, incidentally, there will be slides on the screen, but you'll get copies later if you need them. And the whole session is being recorded. We'll finish this main meeting at least by 7:30. After that, Fight for Europe will carry on in its own original business meeting, our own meeting. If anybody out with Fife wants to join us, they're more than welcome. We'd love to have them join us. But anyway, my Fife colleagues will carry on for another half hour or so. So now before I pass, we go to Mark, it's up to Bill just to tell us how we work our computers in the meantime. So Bill, you're the expert on PCs and computers. We saw you.
Thanks, John. I'm going to interrupt there before you build me up any more than that, because I'm no expert in computers, I can assure you.
We're all looking to you.
I think, I mean, most people on the call just now will be pretty familiar with how to use Zoom, and but just quickly in terms of how we're going to run this meeting, most people, not everybody, but most people will be muted at the moment, because the speakers obviously are not muted, but that's simply so that we don't get too much background noise cutting in. For anybody who's not used Zoom before, the controls are fairly simple. The way to get them to work is just to move the cursor across the screen, and then when you move the cursor up to the top right hand corner, you'll get something which allows you to decide whether you want gallery view. There's a little icon, little squares on it, whether you want gallery view or whether you want to have speaker view. You're probably better with speaker view, which if you click on that at the moment, you'll get my ugly mug. The bottom left hand corner down there, you'll see that the mute, and you will be muted just now, as I say, and you can stop the video if you want to stop your video, also down the bottom left. The two key ones really from the point of view of today are the chat icon, again, if it's on the bottom but nearer the middle, the chat icon. If you've got questions as we go through the presentations, that's the place to put them. Just click on chat and pop them in there, and we'll pick up on that when we get to the Q&A towards the end. The other way to put questions at the end will be to click on participants, and you can then you'll find there's an icon in the participants box which allows you to raise your hand. So you can raise your hand, and then we'll know that you've got a question to ask, and we'll invite you to time permitting, which it should do. We've got plenty of time. Invite you to put your question to whichever speaker you've got the question for. I think that's pretty much all I need to say at this stage. The one other thing I should say is we are recording this this session. There'll probably be some editing done to it before we make it available, but if you don't want to be seen on video, then I've just explained where the cancel video icon is, and likewise microphone, obviously. We were expecting over 70 people on the basis of the booking, but from the looks of things, we're a lot less than that. So background noise ought not to be such a big worry as it might otherwise have been. Okay, I'll now hand you over to Mark, who's our main speaker tonight. Mark.
Well, first of all, thank you, Bill. Thank you, John, and good evening and welcome to everyone who's joined this webinar today. I'm now going to share my screen for the slides, so hope that will. In fact, just I have to sort out something first. Right, I think unfortunately, I've shared them at the end. I have to go back to the beginning. Sorry about that. Right. Okay. Good evening. The theme of the webinar, as you will see, is understanding and campaigning on EU citizens' rights after Brexit. And the idea behind the webinar came from the fact that many members and supporters of the European movement in Scotland and general pro-European community within Scotland wanted after Brexit to continue to show their support for the European ideal, and to do that. One of the ways was to show support for EU citizens in Scotland and to help them protect and assert their rights to remain in Scotland and the UK, to enjoy their full rights that they had previously before Brexit. But we found when we were talking about this, quite a few people weren't entirely sure what those rights were, what they had been, what they will be in the future. So we thought this webinar would be a useful way of helping people understand what those rights are, what they will be, and then, because the European movement is a campaigning organisation, to have a discussion what we actually can do to campaign to assert and protect those rights. So that's basically what this seminar is about, webinar this evening. Sorry. Just a bit about the structure of the webinar. I will be dealing with citizens' rights as they were and are still for the UK to the end of this year under EU law, what those rights will be in the UK after Brexit, to highlight some of the problems that I've come across, and that's both my work as an advocate, because I do sometimes represent European citizens who've got problems, but also more of my work on a voluntary basis with the Citizens' Rights Project, suggest some of the solutions, and also, importantly, talk about what you can do, what we can do to try and assist those who are finding themselves in difficulty because of the way that Brexit is impacting upon EU citizens in the UK in particular. And we'll have the contributions from Maricruz Garcia, speaking specifically about some of the issues to do with universal credit, the problems that's caused EU citizens in the UK, and then Larissa Slaney will be talking about some recent difficulties which have arisen from changes to the rules that EU citizens have to, or the conditions that EU citizens have to meet if they want to become a UK citizen, a British citizen, as well as just a citizen of their original EU member state. I want to start off with just going back really to the beginning and looking at the origins of the European Union. And that's actually important because it has a bearing on the way that citizens' rights have been structured in EU law, but also what happens after Brexit as well. We should remember that when the EU was set up, it was actually set up as a European economic community. And fundamental to that institution was the idea of economic unity across Europe. Now, it wasn't just for an economic purpose. Well, when you bear in mind the European community was talked about after the Second World War and the existence from 56 onwards, but European economic unity was important. It was also, of course, a political objective, primarily to ensure there would never be another war in Europe, because economic unity would encourage cooperation and peace between nations. So that's how the European Union started. Now, over the years, the concept of citizenship of the Union has now developed, and the citizenship of the Union is much more than just to do with economic matters. But it's worthwhile mentioning that economic purpose is still a fundamental of the objective of the EU. And I say this because you will see that explains some of the features of the citizens' rights structure within EU law, within EU rules, and that has an effect on how it's impacting upon EU citizens here and now in the UK, as I hope I will be able to explain. Now, turning to some of the basic areas of EU law. Now, this is quite a complex area, and people will appreciate I'm obviously giving a very brief introduction at this stage. I'm not going to have lots of quotes from legal texts, but there's a couple which I think it's important and probably easiest to refer to directly rather than to try and describe them. And the first one is a directive, as often called the Citizens Directive. I've given the actual reference of those who want to check these things, and that is a consolidation of the fundamental rules of citizenship within the European Union. It is still the EU law today, and therefore law in all the member states. And that has, first of all, in the preamble, a number of very ambitious, grand statements, which illustrate the breadth of citizenship under EU law. It says here, the citizenship of the Union confers on every citizen of the Union a primary and individual right to move and reside freely within the territory of member states. But then, and this is my italics, but I've done that to emphasize, this is qualification, subject to the limitations and conditions laid down in the treaty and to the measures adopted to give it effect. So citizenship of the Union is a broad thing, but it's still subject to limitations. It basically only applies insofar as it is part of the wider objectives of the EU, which is why, for example, in some areas, as we found in health recently, where the EU has very little competence, there's no, the EU's ability to move quickly is limited, and that is why you don't really have many rights in the health side, which you get as citizen of the EU. You will get them because you're a citizen of a member state or a country. So it's a broad principle, but there are qualification limitations. And we see this with the next quote, which is again from the preamble at the beginning of the directive. For free movement of persons constitutes one of, in italics, the fundamental freedoms of the internal market, which comprises an area without internal frontiers, etc. So free movement comes out of the fundamental freedoms of the internal market. So it's all still rooted in this idea of having an economic unity within the European Union, within the European community. And then we go on to a third statement: Union citizenship should be the fundamental status of nationals of the member states. But again, not for everything, but it is when they exercise their right of free movement of residence. So I made that point about overemphasizing about the economic basis of the European Union. Obviously, the European Union has gone a long way beyond that, but as we will now see, it's still very important to have it in the background where we really understand the structure of citizenship rights within the EU. And that takes me then to this question of what are the rights of residence that EU law provides for? What are the rights that EU citizens have in throughout the European Union? The first thing to emphasize, and that's my block, capitals, but it's an important point to remember, that notwithstanding what the tabloid media and some of the Brexit politicians have said or told us that the EU meant millions of EU citizens and even possibly 70 million Turks who come and live in the UK in the future or whatever. EU citizens have never had an unqualified right of residence in other member states. And the way that the right of residence rules are structured is that you have one set of rules for residence for up to 3 months, then there's a rule for right of residence for more than 3 months, which is sometimes called extended residence, and then there's a rule for permanent residence, and I'm going to go through each of those very, very briefly. The right of residence for up to 3 months, that is pretty unrestricted, as you will see, a right to reside for up to 3 months with no conditions or formalities other than an ID card or a passport. Pretty broad, but is certainly very, very broad. When we come to the right of residence for more than 3 months, all Union citizens have a right of residence on the territory of another member state for a period of longer than 3 months if they meet certain conditions. The first one, workers are self-employed persons, straightforward. The EU is about the movement of workers. But there's also people who aren't workers or self-employed, but to perhaps their partners or other citizens, they may be retired or whatever, and they have a right to reside, but they have to have sufficient resources not to become a burden on the social assistance system. Now, actually, European courts have held that the threshold for sufficient resources is pretty low. It's not a very high sum of money was expected. But also there's this requirement that, and this is a real issue, that if you're not a worker or self-employed person, then you have to have comprehensive sickness insurance cover in the host member state, or if you're a student, then you have to have comprehensive sickness insurance cover, and you've also got to assure the relevant national authority, again, that you have sufficient resources not to become a burden on the social assistance system. So workers and self-employed people, there's no extra requirements, but for other people, then you do have this requirement, particularly relating to comprehensive sickness insurance. Now that's important because if you haven't got that cover, then under EU law, if it's strictly implied, you are almost certainly under individual countries' own immigration rules, not to be strictly speaking lawfully resident in that country, because you haven't got the sickness insurance if they choose to enforce it in that way. And that's important because the third category, permanent residence, allows Union citizens who have resided legally for a continuous period of 5 years in a host member state to have a right of permanent residence. But you'll see I put in italics, Union citizens who have resided legally. And of course, as I suspect some people in this webinar will know, if you had applied for permanent residence in the UK as an EU citizen, you would have had to gone through a whole rigmarole of filling in forms to show that you'd be a worker if you were a worker, or to show that you had other status, and people were also getting turned down because they couldn't show comprehensive sickness insurance. So that's the background to the EU citizenship rights within the European Union, pretty broad, but my point is there's still some restrictions, not unlimited. And that then takes us on to what are those citizens' rights after Brexit? Well, the background is that there was pretty early agreement in the negotiations between the UK and the EU on the principles of EU citizens' rights in the UK. You can be charitable as to why that was done by the UK or not. The cynic might say the UK recognised it needed to have 3 million EU workers here anyway, and it wasn't wanting to make it difficult for them to stay, but you know, it may be cynical, but other reason no doubt as well. But anyway, there was agreement early on, and the EU-UK withdrawal agreement has the details of the provisions which apply to citizens' rights for EU citizens in the UK in part 2, and that is the basic legal text guaranteeing citizens' rights after Brexit. What that means, of course, is that EU citizens' rights in the UK are legally binding as an international agreement between the EU and the UK, and they've now been put into effect, or are being put into effect in UK law. Another point to bear in mind is that because these citizens' rights agreement details are in the withdrawal agreement, which is now binding and law, even if there was no deal on the UK-EU future relationship after the end of 2020, the end of this year, Citizens' Rights Agreement is not affected by that. The Citizens' Rights Agreement is there, it is permanent, and it cannot be changed by either party to that agreement. The key principles of the agreements on citizens' rights, and I'm talking here, I've described the arrangements as ones which are for EU citizens in the UK, but these are of course reciprocal arrangements, and there are similar arrangements, not identical. It's up to the member states. They have some leeway how they put into effect, but the same arrangements apply of course for UK citizens in the EU. But the arrangements are essentially these: that EU citizens who are resident in the UK at the end of a transition period, which we now know virtually certainly, as someone changes their mind by next Tuesday in the government, will be at the end of this year, and those who reside now and who is in the UK by the end of this year will have a right to reside, or I shall rephrase, they have a right to obtain a right to reside if they apply for the status, and that's an important point to make. This also applies to the qualifying family members, which is quite a broad category of people who are related to the EU citizens who are resident in the UK. And the close family members, even if they arrive after 2020, or the end of 2020, will still be able to apply if they had a relationship at the end of a transition period and it also still existed at the time that they came to the UK. So some people will still be able to arrive to reside even after the end of December 2020. And basically, the Citizens' Rights Agreement does replicate the EU law rules on extended residence and permanent residence for those who are resident in the UK at the end of a transition period. It's basically moving over from the EU citizens' rights law to putting them into UK law through the withdrawal agreement. And the most important of those rights, of course, are the ones to actually reside in the UK, and that is to be found in what is called by the UK government the EU settlement scheme. Now, this is not actually the EU's settlement scheme. This is the UK's scheme for providing rights for EU citizens, but it's the term which is used in UK law and quite familiar people working in this area. And the essential features of that are that EU citizens and their family members, as you will see, they can apply for settled status if they've been in the UK for 5 years, qualifying years. That gives a permanent right of residence in the UK with some qualifications. For people who are resident in the UK at the end of the transition period, but haven't actually been here with continuous residence for 5 years, they can apply for pre-settled status, and after they've been here for 5 years continuously, they can convert that into settled status. There's an important deadline that anyone who is eligible to apply for status must apply within 6 months of the end of a transition period. So that means they have to apply by the end of the 30th of June 2021. There is some discretion allowed in the withdrawal agreement, which member states have to allow for late applications to be considered, but it's not automatic right to be considered. So the deadline, this is a very important deadline that people to be aware of, is the 30th of June 2021, if people want to ensure they get settled status or pre-settled status. And a final point to make is that obtaining status under the scheme, if someone wants to apply for settled status or pre-settled status, it is actually a right at law under the withdrawal agreement under UK law if they meet the requirements, the fundamental requirements, obviously 5 years to the UK, subject to meeting what is called the suitability test, which is basically where they don't have serious criminal convictions. So unlike immigration law generally, which is very much something which ultimately is up to the UK to decide, it's granted to people. Here people have a right to get the status if they meet the basic qualifications which are set out in law in the withdrawal agreement and in UK law. Just a final footnote that there are similar rights to the rights for EU citizens for the citizens of the 4 countries associated through the EEA and Switzerland with the EU as well. So if anyone's interested in that, there are rights there as well. So that's the summary of the scheme, and there are a number of positive aspects of the scheme. It's probably fair to say, or certainly in my view, and it's probably true that the eventual arrangement for citizen rights are probably more extensive than some people feared they might have been after Brexit. Broadly speaking, there are some exceptions, but EU citizens in the UK at the end of 2020, if they apply for settled status or pre-settled status, they will get rights of residence and other rights as well, which are broadly similar to what they would have had previously under the EU laws to which the UK would have been obliged to comply. There are actually one or two respects where the UK actually gives more rights than existed under EU law or indeed under withdrawal agreement. For example, the UK is not asking people to show they have comprehensive sickness insurance if they are applying for settled status or pre-settled status, and that is something which the UK could have chosen to do under withdrawal agreement, but as specifically said, it will not do for application for settled status and pre-settled status. And for most EU citizens and family members, and I've worked with many now over the last couple of years, obtaining settled or pre-settled status is actually pretty easy and straightforward. The withdrawal agreement makes it clear about this, compared with the difficulties that I know people can have dealing with the UK immigration system and other matters. It actually is relatively easy and straightforward for most people, not all, and that's very important. And it's also true the UK government has publicised and promoted the scheme pretty widely, which again it's obliged to do under the withdrawal agreement by law anyway, but it certainly has done that relatively effectively, relatively efficiently. It's even given a lot of money to voluntary organisations, NGOs to help publicise it as well. So there are positive aspects, and I say that because we need to understand the full picture. But it is also true there are a number of quite important problems and issues as well. The first one, there's an issue of principle, really, which is that many EU citizens understandably object or are unhappy with the idea they've actually got to apply for a status, even if they're entitled to the status, they actually got to apply for it when EU citizens in the UK previously automatically had that status, didn't have to apply for it. It happened because they were EU citizens of the UK. They would have to apply for permanent residence, but they didn't actually have to apply to reside in the UK. So that's a matter of principle, but also some practical difficulties as well. Because the way the system works is you have to apply online, in most cases, one or two exceptions, and the proof of status, the proof you've got settled status, is online as well. There's no physical proof of status. You actually do get a letter saying that you have been given settled status, but the letter also says this letter is no proof of settled status. You have to go to the online link, and that's partly defenders being today's world of being a world where we get all our material information online and the rest of it. Well, that's maybe, but you can see how many people are very nervous, understandably, of not having physical proof of their status. What happens if you're late at night in some airport somewhere else in the world, flying en route to the UK, and the computers aren't working? What's going to happen to you? Very real fears, and that's something which the EU is recommending to its own member states. They give UK citizens physical proof, so that's, I know, is a big issue. Next problem is providing documentation in some cases. You have to provide proof of your national passport or your ID. That seems, I think it's a reasonable thing to demand. But of course, some people who've been here 30, 40 years have actually let their national passport or ID card expire, and actually getting that replacement can be sometimes very expensive in some countries. In some countries, you have to do it in person. You have to go to a consulate in London. If you're living in the Shetland or somewhere, not so easy. And so there's problems like that. And the other thing which people are concerned about is that because of the difficulties caused by COVID-19, in Britain, for example, for some months, the system for applying for settled status, wasn't accepting postal communications, accepting documents by post. Other countries having similar problems. And if you've actually got to get replacement ID cards, or you've got to perhaps get some proof from an employer or something of that nature, you know, it's due now. A year can go by pretty quickly, and people are getting pretty nervous in some cases about potential delays in being able to submit applications for settled status. There are problems for vulnerable people, and that could be perhaps people vulnerable because they don't have a particularly good knowledge of English. For website from the government, well, we does have information in other languages, but you know, the actual application has to be made in English. And there are also, for example, people which I know we've come across in the Citizens' Rights Project, children in care, who local authorities will need to apply for settled status for. We know that by January of this year, a survey by one NGO showed that something like 90% of those children had not get settled status, and if they don't apply for settled status, they will, as anybody else doesn't apply for status by the 30th of June 2021, they will become unlawful residents in the UK thereafter, and therefore could, in theory, well, in reality, face deportation at some stage in the future, or probably more likely in many cases would find that if they didn't have proof of status when they want to get a job or get accommodation or get a bank account or whatever, they would have that not open to them because they couldn't show they had a right to be in the UK. The other point, of course, is that although there are citizens' rights for EU citizens who arrive in the UK before the end of this year, those who want to live, work, or reside in the UK after that would only be able to do so on the basis of whatever the UK decides as its immigration law is going to be in the future. And the indication so far is that although there'll be arrangements for short-term visa-free visits by EU citizens, beyond that, it'll be a points-based system for the rest unless the UK and the EU come to some other agreement on this point, which does not look particularly likely. So if you're concerned about these issues, what you can do? Well, you can raise awareness, campaign locally and nationally on these issues, of course. Some of there's bigger types of things you might want to campaign. Of course, we would probably all like to see us rejoining the EU, which would solve all these problems I want to draw. But even if that doesn't happen, well, can there be some arrangement in the future for at least to have some freedom of movement between the UK and the EU, just as Norway and other countries have? That not on the agenda, I think it's fair to say, with the present government, but that might change in the future. But what about the possibility of some Scottish arrangements, a Scottish visa, as the Scottish government has suggested, to allow some closer links between Scotland and the EU? And that is something which has had support across the political spectrum, and we can remember that back in 2001, 2002, when it was a Labour Lib Dem coalition, there was a scheme to allow a 2-year possibility after graduation for students to stay in Scotland. So there are possibilities which can be developed for particular relationships, closer ones with Scotland and the EU, which could well be developed, even in the absence of any wider constitutional changes or relationship with the EU or whatever. Now, those are probably ones which are pretty broad brush, and pretty ones which clearly are, you know, in the immediate agenda of present government, unlikely to get very far, but still worthwhile putting them on the agenda. But there's also much more immediate steps which could be taken to benefit EU citizens here in the UK, here in Scotland. There's issues about flexibility and entitlement to benefits, time limits for applications to settle status, extending the time limits, removing restrictions on applying for UK citizenship, which I know that Larissa and Maria Krug will talk about later. And generally, it's, I think, important for those interested and concerned about these issues to continue to highlight EU citizens' contribution to Scotland and the UK. So that's some suggestions for what you can do, but we can have a discussion later on about any other ideas that people might have. Just some links and contacts for taking these ideas forward, for actually doing something about these issues and showing that support. Well, first of all, if you're actually not a member of European Movement in Scotland, well, you should join us, support us at least, join our newsletter list if nothing else, and you've got details there on our first link, please look at that. The 3 million were settled. I know that, I think it's Larissa's going to say something about that, or at least because there are links to it in her presentation later. As John said at the beginning, I am also in my own capacity the chair of the Citizens' Rights Project. We have a website which provides information and advice on settled status, other rights and issues, and we organise a whole range of meetings and activities. So please do have a look at that. Circulated as well. It's actually in 7 languages now. We're extending it to other languages as well. And I make no apology for also promoting yet again, our crowdfunder, which we have launched to support the Citizens' Rights Project work. We do get funding from the Scottish Government. We had some from the European Commission in the past. It doesn't pay all our expenses, and we want to expand our activity a bit as well. So please think about supporting if you haven't already done so. It's always great when people retweet and share and like all these kind of things. But even better, actually, to be honest, if you give some money as well, because at the end of the day, likes on Twitter don't actually pay any bills. So I'll make that reminder. People haven't yet been able to contribute. So I think that that's the end of my session. I'm obviously looking forward to question and discussion later on. And I am now going to pass on to Mary Kruth. Could someone just clarify, perhaps Bill, should I stop sharing my screen now, or should I keep it up for Mary Kruth's slides, I think
if you could leave it up, please. I don't think it, well, Mary Kruth, do you want to do your own, or are you quite happy for Mark just to move on just through your slides?
If you can move my first slide, Mark, because I don't have rights, presenter rights. Okay. So, yeah.
Well, welcome Mary Kruth, and perhaps let you introduce yourself as well.
Yeah, no, first of all, I just want to thank Mark and my colleagues of the European Movement for organizing this. And I want to thank you, all of you, because you are attending this webinar when we have an incredible, strange summer date in Scotland, which is totally rare before coming back to the normal weather. So I really feel really touched, guys, that all of you feel so committed to us, to the Europeans, to attend here. Just before introducing my part, I just want to mention very briefly my background, the kind of perspective I come from. I am the founder of the Hispanic Society in Fife and Dundee. I am a councillor for Edinburgh Ward in the Council of Spanish Citizens, although I am here in my personal capacity, and what I am saying is in my personal capacity, but I was involved in the negotiation with the Home Office, the EU27 representative group, which is the group that the Home Office has with delegates, representative of the European communities, the 27 European communities in the United Kingdom. I know the settlement scheme very well because I was involved in the negotiations. Mark has summarized well the scheme. He is optimistic about the positive aspects. I don't think any of those who were involved in that negotiation and the group would say positive aspect, except that simplify some of the requirements of the permanent residency, like the comprehensive insurance. Not to extend my presentation, I'm gonna stick to the point, but I just wanna type here in the chat is my email, so that if anyone wants to contact me after this presentation, please do that. If this presentation is recorded, which I'm happy with that, Bill, the only thing is I would like to ask if the email is not shown in internet or to everybody, but I'm happy with all the activists, but we can discuss this later. So just for starters, I would like to mention that in this presentation with the problem with the access to the universal credit is just an example of the wrongdoings of the settlement scheme and the legal gaps that the settlement scheme, in particular the pre-settlement schemes, has brought about. One of the key messages I want you to take from this presentation is that the EU settlement scheme is a concealed immigration visa. The EU settlement scheme is not allowing European citizens to have their rights, we need to apply through a covered immigration process. Unlike in most of the European countries, that the process is declarative, and I just want to type just this, is an important legal term in the declarative, because this is legal, is the EU settlement scheme, it is not declarative. British citizens living in European countries are simply confirming, in most of the cases, that they live there through declarative process. We don't blame our brothers, British brothers and sisters in euros, but the reciprocity, the principle of reciprocity and the reciprocal agreements that Mark has mentioned, they are not currently happening with the EU settlement scheme and the pre-settlement scheme. And obviously, in solidarity with my European colleagues, and I would like to appeal with your solidarity as well, we European citizens, we will continue fighting for our rights through the 3 millions and through other organizations. And now, without more delay, I just want to go to the first slide. I don't know who has moved the slide. If we come back to the first slide, please. The universal credit, as you know, is the result of the reform of the United Kingdom welfare system. The reform took place between 2010 and 2015, and the universal credit is now the new social security pay system that was designed to simplify the benefit system. This universal credit depends on the Department of Work and Pensions. I totally agree that any sovereign country, the United Kingdom and any other country, has the right to decide who can benefit or who can have access to the benefits system. The universal credit is based on people having to prove what is called the habitual residence test. Can I ask someone who has presented right, could you please move to the first slide, please, rather than the last one? I don't know why the last one has been put.
Mark's trying to do that. Marie,
if not, I
setting
will.
a problem. I'm not sure why.
It's okay. I will continue with that. But basically, to be eligible for universal credit, individuals need to prove that the United Kingdom is the main home and that they have the right to reside in the country. There are several immigration status that satisfy this right to reside requirement. Until very recently, it was the EU settlement scheme. Then we also have the indefinite leave to remain and limited leave to remain. Until July 2019, the Department of Work and Pensions, and I highlight this is not the Home Office, this is the Department of Work and Pension, and how they make a different interpretation of the EU settlement scheme. The Department of Work and Pensions affected the pre-settled status, the pre-settled scheme, as a proof of the right to decide. In July 2019, the UK government changed those regulations, and they made changes in the section 9 of the universal credit regarding who was a person treated as not being part of the, as not being in Great Britain. So European citizens in pre-settlement scheme that were allowed to prove through the scheme the right to reside have to prove now that they were exercising the freedom of movement rights, which are basically related to they have been here as a worker and they have been here as self-employed. There are cases, as Mark mentioned, under the assumption of who is considered self-sufficient, the person who is not working or self-employed but has enough funds to be living in the United Kingdom rightfully under the freedom of movement, because that person might be a student, or that person might be married to a British citizen. Those persons, under the new changes, for example, to access the universal credit, would not be qualified for the right to reside. They wouldn't have the right to reside. And the reason for that could be, for example, that they are affiliated to the NHS when they don't have comprehensive sickness insurance. So this is a problem that we have. The organizations that work with European citizens has been observing that during the pandemic situation, with a lot of European citizens have to apply to the universal credit, the default decision by the Department of the Work and Pension has been a no by default, rather than accepting the pre-settled status. European citizens were asked to provide more evidence. I need to say that the people who are applying to the universal credit are usually people in very precarious situations, that sometimes no written contract, or they are unable to provide additional evidence, or they have been really struggling with this problem. So the 3 million, together with other organizations like the Council of Spanish Citizens, we raised this issue, the European Commission, through our authorities. The legal argument to prove that it's wrong to reject European citizens, to reject the pre-EU settlement schemes as a right to reside, is based in the part 2 of the withdrawal agreement, as Mark has mentioned. And if you, Mark, or someone could please move to the next slide, to the last slide. The next, that one. Is basically this is the summary of the legal argument why European citizens who apply to universal credit in a pre-EU settlement scheme, and using the pre-EU settlement scheme as a proof of evidence, should not have their application rejected, which is the part 2 of the withdrawal agreement and the rights of the stipulations included therein, which is, I don't want to fatigue you with all the legal argument, but the European Commission has been really firm, and that has been the reply to the 3 million and other organizations about this issue, that in their opinion of the European Commission, is basically the United Kingdom has decided to really take a more favorable approach. It's just rejecting by default those citizens. I think as I mentioned, and I just want to finish with this, European citizens, we should not really have to apply or reapply or being rejected, even being put into this pre-EU settlement scheme, because the pre-EU settlement scheme is legally and morally wrong. But I personally think there is no point in using moral arguments with the current government of the United Kingdom, but it's legally, from the point of view that it does not fulfill the principle of reciprocity. Is the pre-EU settlement scheme is telling you that you temporarily you can stay and live here, and then someone will decide at the discretion of the person who look at your application. When you apply for EU settlement scheme, someone will decide if you have the right to stay here or no. There are no pre-settlement schemes at all for British citizens which are being granted the right to stay in other European countries, in most of that. And I think that's why, and I quote the European Commission literally, removing this less secure pre-settled status would be a decisive action to secure the rights of the European citizens in the United Kingdom. And I think that was the key message that I would like to transmit in this presentation. Thank you again for inviting me. And if you have any other questions about this argument and the problems that the settlement scheme is bringing within the current universal right provision, please feel free to email me through my chat. Thank you very much. And I'm gonna now give the floor to Larissa, which is gonna mention another problem that European citizens are encountering, which is we were promised that through the settled status, we will be able to apply for a British citizenship. That was sold as a kind of indefinite leave to remain, and that has not been the case either. Larissa, please.
Larissa, it's Margaret. Do you want me to? Are you going to use your own slides?
I'm going to use my own slides. Yes.
So I'll stop sharing my screen now. Then.
Okay. Excellent. Right. Give me a second and quickly find this. I'll go to slideshow. Right. Does that work for you, or is that too big? That's a bit too big, isn't it?
Fine,
That's
here.
fine. That's fine. That's fine. That comes up fine.
Does it work for you? Fine. Okay.
Yeah.
It's really big on my screen for some reason. Right. Okay.
No, it's fine.
Move all of you across. Right. Okay. Excellent. Super. Right. Well, hello everyone. My name is Larissa Slaney, and I am a German EU citizen here in the UK. I've been living here for over 27 years. And yes, I would like to tell you a little bit about my journey since Brexit, and particularly about the path to British citizenship, which is quite a bumpy one, I must admit. I would like to first of all mention the comprehensive sickness insurance once again, because Mark already mentioned it, and so did Marie Cruz. And Mark quite rightly said that the EU made this a requirement for living in any of the other EU countries. You have to have comprehensive sickness insurance. It's the same in all the European countries. Now, the EU accepted for EU citizens living in the UK to use the NHS, that would be acceptable as CSI, as comprehensive sickness insurance. Now, it was, and yeah, it worked absolutely fine. In 2011, the UK government introduced basically a new way of using this comprehensive sickness insurance requirement. What they wanted from that point onwards was that certain EU citizens living here, take out private health insurance. Now, that was not widely publicized. I mean, I've been living here since 1993, and I know lots of people like me who knew nothing about this. It was introduced, but it was not communicated to us, which they could have easily done by, communicating via our GP practices, for example, or many of us are on the electoral register. They could have written to us. There were ways they could have communicated this to us, but they chose not to. Only people who are, as Mark already said, are students or self-sufficient are required to take out this comprehensive sickness insurance. Mark, if at any point you think you want to correct me, that's absolutely fine. Just jump in, because I don't want to say anything wrong.
Keep on. I'll keep on.
Okay. So people who are students or self-sufficient people, EU citizens, they are supposed to take out CSI, comprehensive sickness insurance. So self-sufficient means, for example, stay-at-home parents or EU citizens who are caring for their British partner. So that's just examples of people who are not working, not in employment, and are not self-employed, but are also not a burden on the system. In 2018, well, and after Brexit referendum, when Theresa May suggested that settled status should be new way of giving EU citizens the right to reside, and said that this would replace the permanent residency, the 3 million campaigned against the CSI requirement, and it was dropped, settled status. So at this point now, we knew we did not need CSI to gain settled status. And the other thing we knew was that settled status was going to replace permanent residency. And thirdly, settled status was going to become the requirement, or the first step, or one of the requirements to then gain British citizenship, if you so wished. Okay, so when I started looking at British citizenship, which was sometime last year, and I looked at the form, there was no question on CSI. It was not a requirement. There was no question on it, and at the end of the form, you get a list of documents you have to provide. Again, CSI or any kind of proof of health insurance, further health insurance other than NHS, was not asked there either. So no, many of us thought, great, settled status is enough. We are now going to apply for British citizenship. Filled in the form, in many cases got the documents checked by an office or an organization that the government uses for the biometric tests. They checked the documents. They said to me personally, everything is fine, you've got everything you need. They sent it off to the government. So at that point, you have to assume that everything is fine. And the government very quickly takes your money. We have to pay straight away, and it's about £1,400. So in May 2020, so very recently, we became aware that there is a new wording in the guidance for the Home Office staff. Suddenly the Home Office staff is asked to explicitly look for CSI in our applications. And it's pointed out that this should be a requirement. They are also told that they can use that they can exercise some discretion, but it's not said under what conditions they can use the discretion. It's all very vague, and it gives the feeling that because it's so unclear, it could be applied inconsistently. Therefore, the 3 million have launched a new campaign last Tuesday, so a couple of days ago, which is called Bye Bye CSI. And I was going to, and I can't now because I'm sharing my screen. I'll do it once I've stopped sharing my screen. Put the link in, so that you can all go onto their website, the campaign page, and I would urge you to write to your MPs and make them aware of this issue. And I will tell you in a second why the prolonged waiting time we're experiencing just now, which I'm going to talk about next, why they are in connection with this new rule are quite an issue. I personally think that is a further reason to write MPs at the moment and say that the CSI requirement is causing a lot of problems, a lot of worries, and is not handled in a fair way. So let me just very quickly talk about the waiting time. So when Home Office tells us that the processing time, the expected processing time is 6 months. And I was told that part of the fee is basically a service fee, so that they, do this, that they process it within the 6 months. Now, time has, waiting time has really increased. So many of us have got to wait. Well, I've now met several people who've been waiting for 14 months and they still haven't got a decision. the Home Office has started to send out emails warning us just before the 6 months are over that we are not going to get a decision by the end of the 6 months. My email stated that coronavirus issue was the problem, was the reason for this. I do know of people who've received these emails back in September. So in September, we didn't have a coronavirus to blame it on. So I think this is an issue, a different issue, that they've got a huge backlog, which I can understand, that's fine. However, applications don't seem to be processed in a chronological order. So as I said, I know of people who've been waiting for 14 months, more than 14 months now actually. And I know of others who applied in January and were accepted in February. Now, if one case was a difficult case, a complicated case, and the other one was straightforward, we would maybe understand this. The cases are very much the same. In both cases, they, I've been living here for a long time, met all the requirements, and CSI wasn't asked for. So CSI would have been an issue for both these cases. So that can't be the reason why. We don't know what the reason is. There seems to be, I don't know. All I know is that don't seem to be working on it in a chronological order. Now this is a problem because guidance for the Home Office regarding CSI does not explicitly say that this needs to be applied to applications from May onwards. It doesn't say that. So there is the possibility that this is going to be applied in retrospect to applications that are still pending. And that is a huge worry for those of us who thought we can apply because we didn't need CSI. And we paid because we thought we can apply because we didn't need CSI. But if we are now refused on the grounds of newly reintroduced requirement, Mark, you can correct me there, a requirement that clearly was not asked for about a year on the application form. Now, if we now are refused, we are going to lose money we spent. So the application fee is going to be lost. And for many of us, especially for those of us who are German, it means that we will have to wait until we can apply again, until we fulfill the requirement. And we will then not have the chance to have dual nationality because the German government only allows dual nationality with another EU state, or in this case, the UK, as long as it's in the transition phase. So this is a further problem for us. And many of us applied at that point because we wanted to have dual nationality rather than having to choose. Right. I would like all of you to have a quick look at this. This is Maslow's hierarchy of needs. And I think it's really important to not just be pragmatic, but also look at what impact all this, the whole journey we've had since Brexit, with the introduction of the settled status and the confusion it caused, with the shifting of goalposts in terms of British citizenship, because the form was changed several times over the last couple of years. What impact this has had on us. And when you look at this hierarchy of needs, what I've heard from fellow EU citizens, they feel that their need for safety and security isn't met. They feel really insecure, they feel really unsafe, uncertain, don't know where they stand. And we've lost a sense of belonging. So country where we felt at home and we felt as equals. Certainly it feels as if we are not equal, well, we certainly feel that we are being treated as second-class citizens and we are not welcome anymore. I think it's really important to not lose sight of this, because the amount of mental health cases has increased amongst EU citizens. I just think it is really important to look at the human beings behind all this legislation. No, we cannot ignore this. This has got a huge impact, and not just on the EU citizens themselves, but also their families. So it's quite a large part of the population that has got to deal with constant uncertainty. Okay, what can you do? First of all, if you could have a look at the campaign page of the 3 million and have a look at the Bye Bye CSI. It would be great if you could write to your MP and make your thoughts heard, and yeah, raise awareness that this is an issue, that there is a lot of uncertainty, and this needs to be dealt with an awful lot better. Preferably that CSI is dropped, at least for all those who have applied for a certain date, or maybe all those you know, up until the end of the transition period who are applying up until then. Help inform other British and also EU citizens, because it's surprising how many EU citizens are still not aware of all these issues, are not even aware that they need settled status to stay here legally. So, no, talk to them, make them aware as well. And you can get more information from the 3 million website, Settled Here for Good. So I'm happy to put all these links into the comment box in a moment. UK Zen, they have got a lot of legal advice as well. And then, of course, Mark's Citizens' Rights Project. And please also contribute to Mark's, not Mark's crowdfunder, but the crowdfunder for the support EU citizens in Scotland. And I'm happy to take questions now as well. I'll stop sharing.
Okay, you're still, yes,
I've stopped sharing.
You start sharing, that's fine. Good. Okay, well, thank you very much indeed, Larissa, and also Mary Kuz as well. Now, we do have time, obviously, for questions. I'm trying to think of the best way on just how to handle this. What I think I'll do is, there are some in the chat at the moment, and what I will do, I think there's only one person in the chat. Actually, I would invite Clive Snedden, made a point in the chat room. Clive, do you want to actually, very briefly, just tell it, tell us verbally, but be quite quick if you don't mind, because it's limited time now.
There we go. I think basically I'm worried that there is bad faith on the part of the UK government. I don't think bad faith is necessarily a legal concept, but it will have consequences. What we were told about the universal credit regulations of saying whether or not you qualify under an EU rule, no, you don't. That sounds like bad faith. That sounds like using administrative means to keep down the number of foreigners in the UK. Reintroducing into Home Office guidance the question as to whether comprehensive sickness insurance is required or not after the withdrawal agreement has been signed, and on the face of what you said, in contravention of that withdrawal agreement, also sounds like bad faith.
Can I make one comment in response on the point about the applications for citizenship? And maybe Larissa or Mary might want to say something about universal credit, but
Yes.
actually, but just on, before we do that, can just anybody else wants to ask a question? No, okay, I'll give everyone time to have a discussion. On the question of the British nationality, the problem with that is that nationality, become British citizen, is a separate thing from settled status. And even when we were in the EU, nationality is essentially something which a member state has competence over, rather than the EU. So the problem is that there may well be, probably pretty dubious, maybe you might be able to think of some legal challenges on the issue of the change of the guidance, but you couldn't do it as an EU point. Having said that, I actually think this is an area where there could be some grounds for political campaigning. Because at the end of the day, if the British government sort of saying, we want all these EU citizens to be here and encourage them to be British, and you're making it hard for them, I thought that might be the kind of thing that might actually get some mileage in a campaigning sense. But I doubt if there's much of a legal point. Can I give maybe Mary or Lewis talk about universal credit briefly, and then we'll get some more discussion.
Cliff, no, thank you very much for your point. And to the people who are in the chat, I just want to mention, I would like to distinguish or differentiate when you say good faith by faith. Let's do not use moral arguments, moral judgments, not because I don't want to, and I believe in ethics, I believe in morality, but the point is, with the British government, it doesn't work like that. Let's focus on legal aspect. And the thing with the universal credit is the Department of Work and Pensions, because I highlight, we are not talking about the Home Office, it's about how different departments of the British government interpret the settlement scheme and interpret the conditions. And that is why the arbitrariness is, and that is why the principle of reciprocity should be honored. Is the Department of Work and Pensions until July 2019 was affecting the pre-settlement scheme, pre-settle status as approved to right to decide. They made changes, which I totally agree, and every country have to do changes to decide who access to the benefit system. But the point is, what the legal argument that the European Commission is telling the Department of Work and Pension is the withdrawal agreement, the part 2, and the 3 articles, the principles I pointed there are telling that citizens who are in pre-settlement scheme has the same protection. If you accept to apply for the universal credit people in settlement schemes, why are you telling me that people in pre-settlement schemes are being rejected and the pre-settlement scheme is not a proof of your right to decide? This is a double legally why those people are not protected, and that's the route that the 3 millions and other organizations like us has chosen. I don't know, Cliff, it does answer your question. It's not a question of good faith, it's not a question of this government is evil or not. We all have our own opinion. I have mine. It's a question. The United Kingdom has signed an agreement with the 27 European countries as their equals. Europe is not a British colony. You don't have to have a better right for you and your citizens. If we are equals, we honor the agreement together each others, and that's why the legal arguments comes. Now the United Kingdom has a series of obligations under the agreements, and of course the European Union, the countries and that they have their own obligations, and thus the agreement itself, although it has to be negotiated and also in further detail, but it's the agreement which provides the legal protection, and the agreement has to be applied in practice for all the departments that form the UK administration.
Okay. Before we go back to Clive, I'm just looking at the chat to see if anybody else wants to ask another question. Given we've got about 10 minutes left for a comment. So,
Mark, there's a quite a good question from Victoria asking about the relevance. Victoria in Stirling, she's a GP, is a practicing GP. She wasn't aware of the CSI aspect, and she has obviously got a lot of EU patients, EU 27 patients, and is concerned about the potential impact on her NHS colleagues who also are EU 27, and whether that's a potential time bomb in terms of NHS resourcing. I suspect that the answer to that is probably that they're covered by virtue of employment, but perhaps that's something that could be answered.
Well, but ironically, you don't actually have to prove the CSI when you use the NHS. I mean, you have various things to generally sometimes to prove you're entitled to treatment. But if you're an EU citizen, and you will get that right under settled status, the problem is that you have to show that you have the CSI when you apply for the nationality or for the
permanent residency
of permanent residence. So it doesn't really have an effect on someone's right to use NHS. I mean, if they've got a right for, because of their status in the UK, then no one, as far as I know, has ever been asked to present their CSI to a GP. And I think, you know, I think it was Lewis pointed out, I think the general assumption was that we had NHS in the UK, which was sufficient to meet the comprehensive sickness insurance test, because most European countries have a different kind of, have an insurance-based health service, many do, which we don't have in the same way. And but there was, I can't remember, there was actually a court case in the UK
pending.
which found out that yes, the CSI requirement was valid legally in the UK, and that's in part of the UK government soon relied upon that. So
that legal case is still pending. I expect that started in 2012. The EU actually took legal action regarding this, because they said that the way the CSI was now dealt with by the UK government since 2011, saying that we needed a separate private health insurance and that NHS use was not enough. The EU disagreed with that and said that was actually against EU law, and they started legal proceedings against the UK government at that point. That was 2012, but nothing has come of it so far, and I don't expect anything to happen before the transition period. So.
And the other part of Victoria's question concerned the colleagues in the NHS who are EU 27 and how that might affect them. I ventured earlier on that was perhaps answered by virtue of the fact that they're employed by the NHS, but of course there might have been a period when they weren't.
I suspect that might be a question in relation to this so-called immigration health surcharge, which a large number of people who are migrants to the UK are required by the British government to pay, and during the last few weeks, the government has said it will not apply that to health services. I think that's possibly what you're talking about. But actually, that is something which EU citizens aren't required to pay and will not be required to pay if they're here with settled status or pre-settled status. It doesn't affect EU citizens who are here now or who will be here by the end of this year. It will be applied, no doubt, if the government keeps doing it, to future arrivals, but I suspect that's what she's referring to. So EU citizens don't have to pay that anyway, that charge, which is not, by the way, a health charge really, because you have to pay it even if you've got insurance. But that's another question. But it doesn't affect EU citizens as such.
Okay, thank you.
I saw a question, Lucianne Pope, about CS. I think that's probably been answered. I think if it isn't, maybe you can unmute yourself and interrupt. I think it probably has been met, I think.
I think Lucy was asking what the difference is. So what the EU required was that people basically have some kind of health cover. It's what they require from any EU citizen who wants to live in any of the other EU states. How that country handles that is up to them. And for a very long time, us being covered by the NHS was absolutely accepted, and that it was in 2011 that was changed, and suddenly we were required, only us were required to take out private health insurance. And I see two issues with that. It's an equality issue for me, because suddenly I'm treated differently from the rest of the population here, despite the fact that I'm paying taxes and I'm paying my national insurance contributions. And I've lost my train of thought now. I can't remember the second one. Yes, but so suddenly we were treated differently, and the EU said straight away, this is not, according to law, this is not what we wanted, and that is a big difference. So now the second thing was that it wasn't communicated. But if I'd been told in 2011 that's what I've got to do to the right to live here, I would have done this. I wouldn't really have felt that it was fair, but I would have done it. But I didn't know. So I mean, when I moved here in 1993, why would I keep checking immigration law on an annual basis or whatever, check if I'm still fulfilling all the requirements? I would expect the government to make this public, and to reach us via the GPs, for example. That would have been the easiest way to do it. the moment you go to the GP, they say, "Oh well, did you not know there's a new rule? You actually need to get CSI."
Can I maybe interrupt, because we've got about 5 minutes left, so I want to.
Sorry, apologies.
No. John Purvis asked a question: are British citizens in the EU having anything like these problems? All I can say on that is the view that I understand is that in most, I mean, there are some. It is up to each country to implement it, as long as they obviously comply broadly with the withdrawal agreement. I think the general feedback is most other EU countries are probably doing a better job than the UK is. Not all. I mean, there are some countries which haven't really come up to the mark either. But I think that's my impression. So unless anybody's got anything to, I don't really know a great deal on that.
If I can weigh in, John, as Mark says, the implementation is done by every European country. In general, with the health are not having those problems, but remember, if you are asking about applying for citizenship for each European country, this is also true that every country had very specific rules, and it might be well true that when British citizens try to apply for other citizenship in other countries, they do encounter other problems. To be fair, that depends very much of the country, because I know in Spain they don't have the problem of the comprehensive sickness insurance, but the main problem they have is to keep the dual nationality, British and Spanish, because of the Spanish part has problems with that, which in my case, I have both. Being a Spanish citizen and getting the British one, I was able to get both. So it depends very much on the country.
There's a question from, I think, Bill, about does the problem concerning physical proof stem from UK's refusal to hide ID cards? Well, actually, no, because actually, most people who have to show their migration status in the UK have to have a biometric card or some other form of physical documentation. And indeed, if you are the family member of an EU citizen, but you are not yourself an EU citizen, you have to have a residence card under the system. I do not really know why they've not gone for a physical proof system. It may just be they thought it was too complicated, numbers involved. The argument's been put forward is to stop fraud, but I'm not really sure that works, to be honest. So anyway, but no, I don't think it's to do with ID cards. I think it's something else, which we aren't really quite sure about. So there's a question about sum up. Bill, I've got one more question here, which was, I think probably been answered the questions actually. Have any more questions come in from Q&A, Bill?
I'm just checking to see if anyone's put their hand up. I don't see any hands that have been put up. There was a question earlier on about the difference between citizenship, pretty fundamental question, difference between citizenship, permanent residency and settled status. And I think you've maybe answered that as you've gone through, but it's maybe something that's worth just recapping on.
Yes, well, British citizenship gives one the rights of everyone who is a British citizen and born in the UK and brought rights to which settled status does not take away or remove your member state citizenship. It is an immigration status within the UK. Your right under immigration law, effectively. So it is not a substitute for citizenship. It's a different concept. Okay, well, if there's no one else. And I don't think there's anybody else. I know that the 5 of you are going to have their own group in a few minutes. I will hand over to John, back to John to do that. But can I say that I hope the information has been useful, but again, to emphasize, all this is about, for us, the European movement. Obviously, it's informative, but also we want to do something about it. So my slides, I think, are going to be circulated later. I think that's okay. Andrea, Larissa's and Maria. You'll see links there. Please use them. Please use them in local groups, and we hope that this will encourage and assist you to do that. Thank you very much indeed for myself for listening to me and allowing me to chair this vote with your cooperation. And I'm now going to hand over to John Purvis, who will take over the rest of the meeting. Thank you, Larissa. Thank you, Mariku, and also thank you, Bill and Caitlin and Joe for helping with the technical arrangements to make this possible as well. Thank you much indeed.
Mark,
Thank you
here's
so
John.
much.
I'm John Powers back again. Thank you very much. It was very enlightening. And to Marie Cruz and Larissa too for, in fact, we've been through this with them before a bit and in our fight for Europe, and we were thoroughly ashamed of our country's approach to this problem, I have to say. And I would reiterate their points and Mark's position that really we've got to, in all honor, got to do something about it to make it work better and fairly and reasonably and morally right, quite apart from the legal aspects. So please do help all the 3 billion and all the other projects that are going to make this a better world. So thank you, and Fight for Europe will now proceed to its normal business, which if you wish to stick around